So regarding litigation, as Farouk mentioned, the cost of litigation in the U.S. is very high, and that is used as a strategic tool in enforcement of IP. Generally speaking, litigation, I would categorize it in competitor versus competitor, and then you have a bigger pool of non-practicing entities versus practicing entities, and they have their own unique considerations. In a competitor versus competitor, what we see on the defense side is the company must have its own IP, because if you don't, then you become somewhat of a target, and your competitor can sue you and just put the pressure on you in certain cases to even acquire a smaller competitor. They amp the pressure to the point that the company cannot stand it and ultimately has to give in, and that they will be the first to acquire that company. Where if you do have IP developed, even if you're not looking to enforce it as an offensive tool, you can have it in your back pocket. Once litigation ensues from your competitor side, then you take some of those that apply to your competitor and sue them back as part of the same lawsuit. And now you have a more of a even playing field, because ultimately if it goes to the jury is going to award similar numbers, and even throughout the litigation you force the other side to take more reasonable positions, because now they also have to defend. So it creates a more level playing field. So it's always advisable for companies to develop their own portfolio, even if they're not in the litigation business.